which is the proposed resolution regarding the bar exam in Washington State. This is a continuation of our discussion from the last meeting. The materials are on page 288 and late materials 138. Now I will turn it over to Governor Knight.
Thank you, President Cicchetti. As President Cicchetti noted, this is a continuation from the discussion at our last meeting. As a very brief recap, the future of the bar exam has been an issue of significant discussion and concern among our members since the summer of 2020, when some, but not all, of the applicants for the bar exam were granted diploma privilege. That discussion has been ongoing for the past year. And I think it's fair to say that although as there will be with any discussion, there's a degree of dissent and disagreement, I do think it's fair that there are three broad areas of agreement among our members. The first is that some type of bar exam is important. It sets some minimum level of competence to practice law, and it gives the public a sense of confidence in our profession. It's important to note that this association, the WSBA, has a duty to the public. Law schools don't share that duty. If we push off to law schools the responsibility of determining the competence to practice law, we miss an opportunity to serve and protect the public. If we do that, the private sector, the profit-driven private sector will rush in and will lose a degree of protection that the WSBA affords. The second area of agreement, I think, is that the way in which diploma privilege was granted was problematic. It was granted to law school graduates, but not to graduates of the APR 6 program. It left this sense that if you could afford to pay for law school, you could get out of taking the bar exam. But if you participated in the Supreme Court's own APR 6 program, you had to take the bar exam. That didn't sit well with some people. The third area of agreement is that there are legitimate and serious concerns with whether the current form and content of the bar exam has a discriminatory effect on historically underrepresented groups in the practice of law. That's obviously unacceptable. We must do everything we can to avoid that from happening, including changing the form and content of the bar exam. I want to thank President Cicchetti for the suggestion to continue this to the April meeting and get feedback from our members. I think getting feedback was the right thing to do. I think it dramatically strengthens this resolution. I think we got feedback in the right way. We sent targeted emails to MBAs, targeted emails to local county bar associations. Individual governors did outreach. We sent every single member a recap in the take note. Our members got the message, but we also were not purporting to do the work of the task force. That's not our role. Our role is, in this context, to obtain the general pulse of the membership and see where they come out. I read every single comment. I really appreciate the comments. The comments are very thoughtful. They demonstrate that our members are really thinking about this issue and that this issue is one of great importance to them. The membership is, the feedback is overwhelmingly in support of the resolution, overwhelmingly in support of continuing some type of bar exam, overwhelmingly in support of reviewing the form and content of the bar exam to ensure there's no discriminatory effect. Across all feedback, 85 to 87% of the feedback was in favor of the resolution. We live in a divided world in many ways. You just don't see that type of agreement on many issues. I think we should take note that our members are largely coming together in agreement on this issue. I also noted that a number of the comments in opposition came from individual associations, MBAs and other associations. I think it's terrific that individual associations are discussing this issue, and I highly encourage them to do it more. I strongly encourage them to communicate their position to the task force and to the Supreme Court, as we did with our prior motion. I think this board should be very clear that any NBA, any local county bar association, any individual should be able to express their voice on this issue, even if it's in complete disagreement with the board. We don't need to approve a section or an MBA from voicing a position on this issue. I would completely support an amendment to the resolution to make that clear, or a separate motion to allow that to happen on this topic of great importance. Our members and our sections need to be able to comment to the Supreme Court and need to be able to comment to the task force on this issue. I hear the calls in some letters that we should do nothing, that we should abandon the resolution, or that we should take no action because the task force is just beginning its work. I respectfully disagree with those calls. And the reason is, when we've done that in the past, we've been met with complete failure. What this resolution is, it is simply a data point of this board's position on a topic at this time. It might change later, but it is the collective information that we have from our members that we support some type of bar exam, and most importantly, that we support a review and changes to the form of the bar exam. It's just that, a data point. The task force can take or leave our resolution. It has no binding effect on the task force. They can listen to us. They can not listen to us. They can listen to parts of what we say and not other parts of what we say. Our duty, I think, is to speak. And what the task force chooses to do with what they hear, that's their decision. And if they choose to ignore it, they can choose to ignore it. But here's what happens when we don't speak. There's multiple examples of where this board has not been involved and it's been met with a failure of process. One example recently is the Mandatory Insurance Malpractice Task Force. It met for over a year. It gathered data from all kinds of groups, but it wasn't until the very end of the process that this board, this elected representative board, this diverse board that has governors from all across the state, connected to the pulse of the membership, we weren't involved until the very end of the process. The problem is it was too late. There was too much momentum behind the task force ideas and recommendations at that time. The result is no secret. Everyone on this board knows what happened. Complete rejection of the task force recommendation. Absolute status quo. No change whatsoever. This resolution is not a status quo resolution. This resolution is a resolution that asks us to look at the bar exam and make changes to the bar exam if there's a discriminatory effect. So status quo is not acceptable. We must do something that changes the status quo instead of something that has time and time again resulted in just the status quo. I know President Cicchetti is trying to now go back with the mandatory malpractice issue and do it in a way that lends the board's voice to the discussion, that lends the voice of sections and MBAs and other groups. That's the right way to do this. That's why I think this board needs to pass this resolution, is because we need to have our voice now. The same thing happened with the MCLE board in 2019. It didn't meet with the board. It presented its own recommendation to add 3 separate CLEs. The board saw it differently. Even though the board strongly encouraged and supported the CLE requirement for diversity and the mitigation of bias, the Supreme Court outright rejected the MCLE's recommendation altogether. Again, total status quo, because we weren't involved at the beginning. We chose not to use our voice at the beginning. Let's use our voice here. Let's listen to our members. Let's listen to that overwhelming support of our members and say, we do think some measure of competence is an important part of a profession. We do think that by shoving this off to law schools, we simply invite in the for-profit sector and we lose an opportunity to protect the public. We do think that we need to review the form and content of the exam to ensure there's no discriminatory effect. Let's use our voice now. Let's be clear that we are not silencing anyone else's voice. Let's include what we need to do to make sure that other associations have the absolute right to comment. And let's be part of the conversation, not outside the conversation, to help result in a better outcome. I think procedurally, I want to comment on, I believe because this matter was tabled from the prior meeting, that Governor Grabicki's motion to adopt the resolution is still on the table. I don't believe we need another motion, but please correct me if I'm wrong, Parliamentary Stevens. And I also understand that Governor Grabicki may have an amendment to the resolution. So I would encourage a discussion on that amendment as well as the underlying resolution, and as well as the discussion of how do we make sure that MBAs and sections can individually comment to the court. Bottom line is that in civil discourse, I think more voices part of the conversation are better than fewer voices. I think the answer, if you disagree with someone, that party should be silent and not participate is wrong. I think the right answer is invite everyone to the conversation. This is our opportunity to be part of the conversation. That's what I believe this resolution does. And I encourage this board to use its voice to communicate with the task force. Thank you.
Thank you, Governor Knight. Just as a clarification, I think maybe perhaps the MBAs are a little bit different than our sections and do not need to go through the WSBA for any kind of comment approval. They can comment directly to the Supreme Court as they like. Your other comment about listening and receiving comments, I understand even today we are continuing to receive comments. I believe the Northwest Indian Bar Association has sent an email to Governor Abel. Perhaps he will share that with us at some point. There's been other comments that are coming in. I refer you to your email to review additional comments from various individuals so that we take all into consideration. I see 3 hands up. I'm going to first go around with the Board of Governors, and then we'll eventually have public comment. So to begin, we have Governor Angevell, followed by Governor Grabicki.
Thank you, President Cicchetti. The Diversity Committee did have an opportunity to weigh in on this, and I'm wondering if I might have permission to have my co-chair speak to the responses that diversity received and our position at this time.
Is Governor Jarman available?
Good afternoon, Mr. President. I am here and available.
Governor Jarman, welcome. I'm going to treat that as a referral from the governor for time. And so why don't we hear from you now?
Thank you. And hopefully you can hear me okay and my connection is fine. You may recall that I was present at the last meeting in which this resolution was presented. I specifically, on behalf of the Diversity Committee and on behalf of the Minority Bar Associations, urged that you set this resolution over so that there would be meaningful opportunity to provide feedback. In making that request, I urge you to consider the promises and commitments that you had made to minority bar associations and minority members of the Bar Association, that you would make more concerted efforts to include us, to welcome our participation, and to genuinely listen. The Diversity Committee appreciates that you've done that. Now, we believe you're at the most critical point of this process, where you are tasked with demonstrating that those commitments were more than empty or gratuitous promises, that you will now take action consistent with the multiple voices that you've heard. The Diversity Committee, in its own capacity and in support of the minority bar associations, a number of whom you've heard from, are asking that this resolution be abandoned. Our letter can be specifically found at page 138 in the late materials. As we set forth in that letter to this body, the task force is going to be uniquely situated to examine the issue of the licensure process. That's the crux of its very construction. To that end, it's going to be looking at the history of the bar exam, whether it serves its intended purpose. It's going to look at the issue of disproportionality and any alternative means. We maintain that a blind fidelity to a bar examination process constructed during a period of time, and which is most likely that most individuals who look like myself or the Minority Bar Association membership was likely not even at the table. We are simply asking that you allow the task force to do its work. More importantly, that you allow the process to be completed without any predetermined conclusions about what the ultimate outcome could be. At that point in time, you can make an informed determination as to your position. I guess, and I'll defer to Governor Angeville to some degree, if she'll interrupt me at this point. But I've listened to the comments that were made by the governor introducing the resolution, and the idea that the overwhelming responses that he has received are in support of this resolution. I guess it sort of begs the question of an understanding of the percentage of your members that identify as people of color or underrepresented groups, or with in individuals who are first generation law students. Where is your diversity, equity, and inclusion informed lens that accounts for the disproportionality inherent in what you characterize as this overwhelming support of your members in support of this resolution? Surely that irony cannot escape you. You have received multiple letters from various minority bar associations, among them the Northwest Indian Bar Association, Washington Women Lawyers, the Vietnamese American Bar Association, the Lauren Miller Bar Association, the Filipino Bar Association, Hugh Law. Multiple minority bar associations have written. Right now is this Board of Governors' opportunity to demonstrate that more than gratuitous promises or empty words about receiving our feedback and listening, that you're actually willing to meaningfully account for that feedback and take action consistent with that. I'll defer back to Governor Angeville.
Thank you, Governor Jarman. Governor Angeville?
And I would just reiterate the point that the feedback from the minority bar associations should not be underestimated or undervalued. These associations represent literally hundreds of members. So I just hope that my fellow governors take this into account when considering whether or not this resolution should go forward. I also ask that the task force be allowed to do its job uninterrupted by us as a board. I think that it's a bad look for us to be second guessing or providing a foregone conclusion to the task force. And those would be my comments. Thank you.
Thank you, Governor Angeville. Governor Grabicki?
Thank you. Let me first point out in the resolution the important particular article. In paragraph 1 of the resolution, we talk about a continued requirement of passing a bar exam. This resolution in no way endorses the current bar exam. I suspect that the current bar exam is inequitable and discriminatory. All this resolution says is a form of examination should be a requirement for licensure. It doesn't say what the type of exam should be. The task force is going to deal with that among other issues. I do wish to offer an amendment, which I hope is viewed as a friendly amendment. At the end of the third resolution paragraph, I would add a sentence that says, the WSBA commits to working with testing and academic professionals to accomplish this review. And then following up on Russell's comments, I would add a paragraph 4 that says sections of the WSBA are authorized to provide comments directly to the Supreme Court without prior review or approval of either the Board of Governors or the Legislative Committee.
Thank you, Governor Grabicki. Parliamentarian Stevens, will you put that hat on for a moment and let us know where we are with regard to the pending motion from last meeting and any amendments that we may be considering?
Okay,
now.
so I believe the pending motion is properly in front of you because you actually gave it a time and date certain, and we're at that time and date. However, I think Governor Grabicki, this idea of just having these rolling friendly amendments, Governor Grabicki needs to go ahead and make it formal as an amendment for the Board of Governors to adopt as an amendment. So there should be an amendment, a second, and then either debate or vote.
Governor Grabicki?
if that's required, I'll do that. Since I'm the original proponent of the motion, as I recall, doesn't it change things a bit?
Okay. So you were the original, okay, because I thought that was Governor Knight in his proposal, but you are the,
I believe
I know you moved to have this tabled. I thought you had moved to have this table, but okay.
The way he got away with it was because he was the original motion person. That's how we got there.
Okay. Then Governor Gravicki, why don't you propose your change and get a second?
I propose my change as previously outlined.
Do I have a second? A second?
I will second Governor Gravicki's.
All right, we have a motion and a second. Governor Gravicki, I'm going to ask you to be to formulate that specifically while we're asking for more comments so that we can rephrase it specifically when we come back to it. Governor Stevens, followed by Governor Boyd.
So there are a few things I wanted to comment on. First of all, I am appreciative that we are still taking in comments. And that's because I had heard some discussion before that I would reject, and I hope the governors will reject, and that is, it is never too late to send in your comment. And that's especially important if we talk about engaging our members. We should always be open to hearing from them, however they come to us, when they come to us. That being said, I've looked at the comments, and they're kind of in three, I think they're in three pots. Some of the comments are absolutely about, we must have the bar exam. And that's without any distinction between the current one, a new one, or a different one. It's have the bar exam. The other comments, there are a series of comments that really are reactions to the diploma privilege. And I mean, what's interesting to me about those is actually, I think that issue has already been dealt with by the court. It's something that if we actually look at the objective reasons, then we're talking about early on in the pandemic and all kinds of questions regarding how we could safely even have an exam. We've now figured that out. And I think that was as much a reason for the court saying, no, we're not going to do diploma privilege. And there might have been other conversations, but, this idea that we're going to just have this regime of diploma privilege, I think has been seriously dealt with. The third area, and I want to be clear, because I've looked at the comments, especially from minority bar associations, and a number of those comments, including the comment from the diversity committee, was really, now is not the time. This is premature. And I actually agree with that. So here's my take, and the majority of you may do whatever you do, because I don't know that I'm in the majority, but I don't think you can actually honestly say, hey, we know there are problems, and we want you to work through problems, and we want you to overcome discrimination, we want you to do all those things. However, no matter what you do, no matter what you see, no matter what you find, you must have this thing called a bar exam, regardless of any other information that comes in. And that's regardless of anything that is found. And that is also just an interesting posture given who's on the task force. Because these aren't people who are generally saying, let's get rid of the bar exam, et cetera, et cetera, et cetera. But, I think to whatever extent folks are fearful that our life is going to change, okay, we've got to do something now. Well, I don't know that we have to do anything now, but allow the task force to do its work. And, you know, I don't think it's as much I don't think the question is the exam as opposed to what is the appropriate measures we want to have for licensure. They're looking at the broader question, and how you get there are the things they're going to have to deal with. So I don't believe actually Governor Knight and Governor Abell, especially because you all have spoken to it, that we've just got to do this right now. That if we don't even wait till the first draft, we are out of luck in terms of weighing in. I don't think that's true. But I think there's a need, and sometimes with populism, there becomes this need. We've got to speak on behalf of our members, even if our members also don't know any of the information that's going to come forward to the task force. I think we should speak on behalf of our members after we hear, and we share that information with the members. So I'm going to be voting against this. And, you know, I don't know what practical effect this has, but for those of you who believe this will change the course of the work that's to be done, okay, I don't think that's true. And if it doesn't change the course of the work that's to be done, I don't know what this resolution is supposed to accomplish. Thanks.
Thank you, Governor Stevens. I have Governor Boyd, followed by Governor Abel, followed by Governor Pertzer, and then Governor Dresden.
Thank you, President Cicchetti. My comments are in line with Governor Stevens's last point. My issue is one of timing. I definitely think we do need to comment. I think we should choose to comment and use our voice when our voice is going to be most powerful, though. My concern is that commenting now without hearing any of the discussions that the task force is having, or learning any of the findings that the task force makes, or being able to talk to more of the members and the sections and the minority bar associations, will mean that our comment isn't nearly as meaningful as if we waited to learn some of this information. So I'm a fan of waiting to review some of the data first and then giving a position. At this point, I plan to vote no on the resolution.
Thank you, Governor Boyd. Governor Abel.
Well, thank you, Mr. President. A few comments. First of all, I want to make sure that my fellow board members have the letter from Sarah Lawson from NEBA. That should have been forwarded on to everybody. Is anybody able to shake their head or not? Okay, I'm seeing some thumbs up, so that has gone out. I serve as liaison to NEBA. It's a fantastic organization. I'm delighted they submitted comments. I also want to echo some of the comments from Governor Knight about the responses that we've received. I think it's very clear that the vast majority of the comments that we've received have been very strongly in favor of the proposed resolution. I don't think those comments should be ignored, but I also think the comments that we've received in opposition to the resolution have been constructive and helpful. And I also want to say that this organization, the WSBA, is uniquely well suited to have this discussion. We are the only statewide mandatory bar association of which every member of our profession belongs. And so this is the forum to have this discussion, this debate, and I'm just very pleased that we are having it and that we're bringing it forward here today for action. It does seem to me that the biggest question that I have heard, and this goes to Governor Boyd's comments just now, is that it goes to a question of timing. And it may be that some of the commentators have said, look, you know, maybe that ultimately we believe the resolution is appropriate, but now is not the time to make it and to offer it. And I just respectfully disagree with that. And the reason for that is, as I mentioned at the prior meeting, I served on the bar structure task force, and my observation was that, at least in that process, which I thought was very well executed, that the time to have meaningful impact was in the I would say roughly the first half of the process, and that the sooner that an organization or an individual or an entity was able to weigh in an informed and reasoned manner, the more likely it was to have a positive impact on the discussions going forward. And so I think there is a window to be maximally effective. I think we're in that window. And I think this reflects the position that the board has taken in the past, both with regard to diploma privilege, as well as the wisdom and the efficacy of a bar exam. So I do think the timing is now. I think the discussion has been taking place within the profession now for some time, and it's only gone to an increased, level over the course of the last month or so. So I think we've got a lot of information. I think it's helpful. And I think now is the time. So thank you, Mr. President.
Thank you, Governor Abel. Governor Pertzer.
Yes, thank you, President Schicchetti. I'm going to echo some of what Governor Abel said, but also have some additional comments. And as Governor Knight said, this is a data point for the task force to consider. And I want to bring us all back to our positions as governors for our respective districts. We are the voice of our prospective district. And when we get comments from our prospective districts, then I would urge that it's our responsibility not to only share those comments, but to be consistent with those comments when we set forth a vote. To suggest that your individual opinion is better than the collective opinions of our members, I think is fairly short-sighted. This is the beginning of the task force, not the end of it. And so at this point in time, respectfully, the task force should know that the overwhelming members of the Bar Association are in favor of a bar exam. I'm not aware of any other professional organization that does not have some type of a licensing exam. And so that is the beginning of the dialogue. If there is discriminatory parts of the bar exam, then that certainly is what is gained or is set forth within the resolution, is to take a look at that. It's not say to ignore it, it says to take a look at that. But there's a presumption I'm hearing from some comments that because there is the majority of the members of the bar are in favor of a bar exam, that in and of itself is discriminatory. That seems to me is a little bit short-sighted, because you're concluding that the bar exam is discriminatory because there's a bar exam. That's not what the resolution suggests. What the resolution says is that we are in favor of a bar exam, which is what our members are saying. So we are overwhelmingly in favor of a bar exam. To the extent it needs to be changed in some fashion, then so be it. But the task force should know what the rank and file lawyers within the state of Washington believe, and us as the governors, as the representative of our particular districts, I believe have a responsibility to the task force and to this board to let them know. And so to say that because I don't believe in this resolution personally, that I'm going to override the thoughts and the concerns of the balance of my members of my district, I think is a bit short-sighted, and respectfully, I think that's the wrong way to take it. But I'm only one voice of the multiple governors here, so take it as a will, but we are the representatives of our particular districts. We have a responsibility to the members of our particular districts, and we should vote accordingly.
Thank you, Governor Pertzer. Governor Dresden.
Thank you, President Schicchetti. Well, first of all, I'm really enjoying and appreciating the discussion here. That's civil and well-reasoned, and I really thought Governor Knight made a particularly well-argued presentation at the beginning. I think, he talked about sort of the three broad areas of agreement, and I find myself largely in agreement with those as well. I guess I also feel that more voices are better, as he noted. I guess I don't see how that necessarily follows that this resolution should be the result of that of those areas of agreement. And because I guess I'm echoing Governors Boyd and Stevens to some extent here, I feel that this resolution sends an at best ambiguous message of saying, and it specifically says, we support the work of the task force, but only so far, but only if you decide that a bar exam is going to that we need to have some sort of bar exam. And it just seems there's a bit of cognitive dissonance there. I also note that a lot of the member feedback, my sense of it as well, at least in terms of the individual feedback, that there are many more that are strongly in favor of a bar exam. But it doesn't seem that they're necessarily responding to the resolution per se. They are, that is to say, they're asking a question that hasn't been asked. And And in fact, the question before us is not whether there should be a bar exam or not. The question is whether we should pass a resolution in favor of keeping the bar exam mere months after a task force has been formed to study this this issue. And it sort of occurs to me, and I talked about this with a couple of people, has the BOG ever done this before, where shortly after a task force has been formed, where we come out and basically say that we think you should, your findings should be in this direction. I hear Governor Knight when he says that we've tried that before. We've tried waiting until the decision's been made or findings have been made, and it hasn't worked. I guess I'm not persuaded by that. I think that it sort of sets us up to be in potential conflict with the Supreme Court. In a way, I think there was a gentleman named Ronald Park who'd written something in some of the feedback that talked about this, where it's there's some potential tension there where we're going to take a position that's going to be completely opposed by the Supreme Court. And I think it is important to recognize that this is just a resolution. This is not taking action. It's not, as multiple people have said, the task force can take it or leave it. And so I don't want to sort of overstate the importance of what we're doing here, because we're not actually taking action. We're just, I think we are providing a data point. My last comment is I guess it just feels to me that what we're doing here is, in some sense, a reaction to the diploma privilege from last year, that I wasn't on the Board of Governors at that point, but it was, but I would have voted against it had I been on it. But it seems like we're saying, we really didn't like it then, and we still don't like it, and and we want to make sure that this doesn't happen again. And by the way, at least my sense is that it kind of seems like we don't trust the task force to come to that decision. So we want to tell you how you should come out. So I continue to have some pretty strong misgivings about this resolution. I think I absolutely agree that we have a role to play, that we can and should weigh in on this, and that we should speak our minds, that our members should speak our minds. I just feel that, particularly right now, so soon after the task force has been formed, that it's not appropriate to do so now. I think there will be plenty of time later. That's my opinion. Thank you.
Thank you, Governor Dresden. Governor McBride.
Thank you, Mr. President. So sometimes when I listen to these conversations, I think maybe I have a different lived experience, both before and as an attorney. And that's going to be my first and my third point. And don't worry, there's only going to be three, and it won't take too long. My first point is, my lived experience is the barrier for a first-generation lawyer. The barrier was law school. It was the cost of law school. It was 3 years of not being able to work full-time and work at nights. And I find it interesting that the task force, at least our conversations, have focused in so narrowly on the bar exam as being this barrier, whether it was in the past, but it certainly has not been the barrier in my mind. The second point is, in 2 years on the Board of Governors, both on the Board of Governors meetings and also on the legislative committee, I've consistently voted to allow sections, committees, individuals to weigh in, whether it was in front of the legislature, whether it was to the Supreme Court. I believe in that. I'm not worried about people being able to speak and be heard. It may be successful, it may not be successful. And so when I look at this issue, I'm like, it's the same issue to me, which is, this is a chance to speak up and be heard. And I don't think we should be frightened by that. My last point, once again, is 10 years ago, I worked with a number of tribes. We worked pretty hard to make sure that Indian law wasn't taken off the bar exam, because we saw the efficacy and the benefit of exposure for all attorneys. Treaty Indian law was important. And so when people say, well, it's too early, you say you want to change the exam, but you still want to have an exam, I don't think that's inconsistent. I think it's okay to say, yes, there should be an exam. Yes, it can look differently. I might be advocating for inclusion of certain topics on the exam that I think benefit all attorneys, not just practitioners in that specific niche. But I do think at the end of the day, this is about what's wrong with us speaking up at this time. The individuals on the task force that I've spoken to are probably of a different view on this issue. We shouldn't be scared that somehow this is going to close debate. I think it actually might actually start the debate, and that would be a healthy thing. So I'm going to vote for this.
Thank you, Governor McBride. All right, I'm going to do last call for governors to comment, and I'm going to turn it over to public comment. Governor Knight. You're on mute, Governor Knight.
I believe Governor Peterson was ahead of me, but I'm happy to jump ahead of him.
I saw your hand first. So
okay, good. Thank you, President Cicchetti. Just in response, I think a lot of the comments in opposition have to do with timing, which I understand. I want to have sort of a big picture view of where we are. This board has often been criticized for being slow to act. This board has also often been criticized for being out of touch with our members. I think where we tell our members that we're putting this resolution on for action in April, and where we get support overwhelmingly in support of the resolution, it sends the wrong message to say, no, we're not going to act on it today. So that's why I do think it's appropriate to vote on this today. And I appreciate those comments about timing, but I think now is the right time. And just because now is the right time doesn't mean that it's the only time. You know, if this board's position changes, we can address that again later. But right now, we have a clear directive, I think, and I think we should act on it. Thank you.
Thank you, Governor Knight. Governor Peterson.
Thank you, President Cicchetti. I really just have 2 points, and I'll try to be brief. You know, I mean, obviously, there's a number of relevant stakeholders here. We have sections, we have members, we have WISBA, we have the Board of Governors. And I guess at a very core level, I always feel that everybody should be able to give their input to a task force or a committee or the Supreme Court or whatever organization we're talking about. And so it does, I guess it bothers me that, you know, that a lot of people want the task force to have people's opinions, but just not your opinion, even though you're a relevant stakeholder as the Board of Governors. So, I mean, I guess, you know, that is something, and I don't know the answer, but, you know, when relevant stakeholders are being told, we don't want your opinion, that just doesn't rub me right. I mean, let's assume, for example, that we don't give our opinion now, we don't pass this resolution. I can assure you that if we do this a year or 2 later, what we will hear is, why didn't you tell this to us a year ago? Shame on you. I mean, you know what, you let us do a bunch of work and then you don't tell us for, you know, to the very end. I can assure you that if we don't, you know, say something now, that's the response we'll get in a year or 2. I don't know what the right answer is or is not. I think a lot of good points are raised. I just know that, you know, when you're talking about businesses and companies, the best functioning businesses and companies always reach out to all the relevant stakeholders and make sure they get input from all the relevant stakeholders. And by doing that, that's the type of process where almost always the best result is reached. That being said, I'm very happy this task force has been put into place, because I think, maybe there is a way to do this differently or better, and we will see. But the situation does concern me. I'm not sure how I'll vote, but the situation does concern me. Thank you.
Thank you, Governor Peterson. I've got 2 more governors in line, and then we have several members of the public membership who want to talk. So we'll make sure that we have enough time for all of them. Governor Gerbicki.
Yeah, I just want to point out that the amendatory language that I proffered Reading in part, the WSBA commits to working with testing and academic professionals to accomplish this review. That is going to be our authorization to engage outside professionals to figure out what is right, what is equitable, what is non-discriminatory. The task force doesn't have its own budget and its own resources. We do. So this is an opportunity for us to contribute and move this process forward in a way that should get us to goals that we all share.
Thank you, Governor Grabicki. Governor Stevens.
So I guess when I hear the opportunity to contribute, I still am questioning this resolution. I believe a communication to the task force that raises our concern and asks them and even offers to help with a public process to make sure they hear from our members, sections, subdivisions, MBAs, et cetera, is an appropriate thing to do. I also, as I look at the membership itself of the task force, that I do see there are individuals who are in the professional field of bar examination, et cetera, and I think their work is to be done that way. I guess my tack would not be to have staked a position as opposed to raising questions and asking them to ensure that they look at X or Y or Z in terms of comment. And you know, my concern is once you state a position, it's very hard to come off of your position. It's really hard to move away from a position that you have taken, as opposed to, you know, factually expressing. I don't believe they are unaware that there was a lot of negative feedback regarding diploma privilege. In fact, this board was against that use, and they saw it for themselves. So I'm simply saying that trying to weigh in and tell them what they ought to do, as opposed to offering to assist them and asking questions, is a far better way to go about it, and and allow them to do their work. As it relates to the other comment, and I think about Governor Knight's comment about things that have failed. Well, one of the things I would suggest, at least in terms of our best practices, and if you notice, I am doing that, but we will quarterly have a more substantive report, is that I do worry in terms of our own committees that we send things off and don't hear from them until they're ready to give their final report. That is bad practice. So I would always hope that there would be, we would, with our task forces and our work groups, that we're going to have a follow-up and a feedback loop and information that comes to the board before we come up with our final recommendations. I just don't think this is the time that we have to stake a position. But I think it is a time where we have to make sure that we're concerned that the task force takes in, all of the voices that we're hearing and that they're aware about. So I think there are different ways to do it. I don't think taking a position is the way to do it at this early time.
Thank you, Governor Stevens. All right, we have 3 people in the queue for public comment. We're going to take a quick break about, let's say, till 2:45, and then we'll come back and we'll take public comment. Thank you.